We looked afresh at all the materials available to the Home Secretary, both closed and open, affording a due margin of appreciation to her own decision. We were satisfied that the prescription decision was a justified and proportionate interference with individual rights. We emphasised that the prescription decision was not merely a judgment based on Palestine Action's past activities. It involved an assessment of future risk to national security if Palestine Action was not prescribed. A pattern of escalating behaviour was obviously highly material. In this context, we noted that the Home Secretary took the ultimate decision to prescribe on the same day as and after the Bryce Norton incident, when Palestine Action activists broke into RAF Bryce Norton and damaged 2 military planes. This was a serious incident in evidencing the escalation of Palestine Action's activities, threatening national security and violating the rights of third parties. When the severity of the effects of prescription on the rights of individuals are balanced against the importance of the objectives of protecting national security and the rights and freedoms of others, affording an appropriate margin of appreciation to the Home Secretary's decision, we found that the latter, in this case, outweighed the former. On this basis, having regard to the matters taken into account under the first 3 Bank Melak questions, the impact of prescription on the important Article 10 and 11 rights of individuals on the one hand, and the consequences of non-prescription on national security and the interests of the community on the other, we concluded that the prescription decision struck a fair balance. We recognise that the prescription of an organisation like Palestine Action is highly controversial. We recognise, too, that Palestine Action is supported by many otherwise law-abiding citizens and that it is engaged in peaceful as well as non-peaceful protest. It is nonetheless a fundamental mistake to overlook the fact that Palestine Action overtly promotes unlawful violence amounting to terrorism. It is not, as it claims, a direct action civil disobedience protest group like the suffragettes operating transparently in the open. It is a covert organisation operating with secret cells to avoid the detection and prosecution of those using violence to destroy the property of third parties. Palestine Action's activities have caused injury as well as property damage. And at no stage has Palestine Action suggested that its terrorist activities were either a mistake or an aberration. Rather, Palestine Action has lauded those who took part. The contents of the Underground Manual provide good evidence of Palestine Action's continuing intention to promote the use of violence, regardless of the risk that this will result in serious damage to property or serious violence against members of the public. Ultimately, we have had to balance the free speech and freedom of assembly rights of individuals against the rights of third parties and the national security of the communities of the UK. We have done so by applying well-established legal principles, allowing the appropriate latitude to the decision that Parliament entrusted the Home Secretary to make. The Home Secretary had both the institutional competence and the democratic accountability to make that decision. The prescription decision was not unlawful. We set aside the quashing order of the 25th of February 2026 made by the Divisional Court.
My name is Lisa Minerva Locks. I'm going to be reading out a statement on behalf of Huda Ammori, who is the claimant and the co-founder of Palestine Action. And this is her statement. We are surprised by today's judgment after a panel of senior judges on the High Court, including the President of the King's Bench Division, decisively ruled that the government acted unlawfully in prescribing Palestine Action because of the significant interference with the rights of freedom of expression and peaceful assembly. We will fight this all the way. We will seek permission to appeal to the Supreme Court and, if need be, take this to the European Court of Human Rights. And we are confident that we will ultimately succeed, because criminalizing peaceful political protest in this way is a flagrant violation of our fundamental rights and freedoms in Britain, protected in the Human Rights Act, which enshrines the European Convention of Human Rights. We will not stop fighting. We will not stop fighting to overturn one of the most extreme attacks on free speech and the right to protest in modern British history. This unprecedented abuse of power has devastated the lives of thousands of people, while silencing dissent over Israel's slaughter of the Palestinian people during the genocide, when that dissent could not be more urgent. This is the first time in British history that a civil disobedience group has been prescribed as a terrorist organisation, placing Palestine Action alongside ISIS and Boko Haram, despite the fact that we do not advocate for violence, and we exist to save lives by disrupting the supply of weapons used by Israel against the Palestinian people. Throughout these proceedings, the government accepted that this prescription was based on property damage, not violence against people. By the government's own logic, then, the suffragettes, anti-apartheid activists, and the anti-war direct action groups that Keir Starmer himself once defended as a lawyer could have been labelled terrorists. The British public knows that taking action saves lives and is not terrorism. We were banned because Palestine Action's campaign against Israel's largest weapons manufacturer, Elbit Systems, cost the company millions of pounds in profits and contributed to the loss of lucrative contracts. This prescription has always been about protecting the interests of weapons manufacturers and appeasing pro-Israel lobbying groups, not about countering terrorism. I have been overwhelmed by the extraordinary outpouring of support for Palestine Action since this ban was imposed. More than 3,400 people have been arrested for defying it, risking up to 14 years imprisonment. I have been in awe of the courage shown by thousands of people, from priests and pastors to retired doctors and former magistrates, including many elderly and frail or disabled people, and many who had never protested before, but nevertheless chose to stand up for our rights and for justice for the Palestinian people at immense personal cost. Their futures continue to hang in the balance while this ban remains in force. Every day it continues, this prolongs the injustice suffered by thousands of people, wastes millions of pounds of public money, and places further strain on an already overwhelmed criminal justice system, creating a further backlog in the courts and risking adding to already overflowing prisons. it is clear that thousands of people will continue to defy this absurdly authoritarian ban. And the police have already said that they do not have capacity to arrest everyone who defies it, showing that prescription is simply unsustainable and that ultimately there is too much opposition for it to be enforced. The sentencing of 4 young Palestine Action activists as terrorists, despite them not having been convicted of any terror offence and without the jury being told that they faced terrorism sentencing, is one of the gravest miscarriages of justice to flow from this prescription. They acted to prevent further loss of life by destroying 40 military assets belonging to Elbit Systems, including killer drones used in Israel's massacres in Gaza. We will fight to overturn those sentences. We will continue fighting for every person whose life has been upended by this prescription, for the right to protest war crimes without being criminalized as terrorists, and for the liberation of the Palestinian people who live under constant threat of weapons made on British soil by Elbit Systems, Israel's biggest weapons supplier. I will now read a few words from myself, much shorter, but everything I say from here on is my words, and I finish the statement from Huda Ammori.